Good morning. Good morning again. It is truly an honor to introduce our keynote speaker today. Pamela Carmen is the Kenneth and Harle Montgomery Professor of Public Interest Law and co-director of the Supreme Court Litigation Clinic at Stanford Law School. She previously held chair at UVA and has been a visitor at Harvard, Yale, NYU, and other leading law schools. Professor Karlan is a graduate of Yale Law School, in addition to having earned a master's in history and undergraduate degree with distinction at the same institution. After law school, Professor Karlan clerked for Judge Abraham Stouffer on the Southern District of New York, and then to Justice Harry Blackmun on the United States Supreme Court. Professor Karlan is a distinguished scholar of constitutional law and litigation, particularly with respect to voting rights and anti-discrimination law. She has written dozens of important articles and is the co-author of leading casebooks on constitutional law, constitutional litigation, and the law of democracy. Accordingly, she is an elected member of the American Law Institute and the American Academy of Arts and Sciences. Her scholarly achievements by themselves constitute a stunning career. Her contributions to society as a practicing attorney equally do as well. She recently served as Deputy Assistant Attorney General in the Civil Rights Division, receiving the Attorney General's highest awards for exceptional service. She has also served as the Commissioner of the California Fair Political Practices Commission, responsible for implementing and enforcing the state's campaign finance and lobbying laws. As Director of the Constitutional Litigation Clinic at Stanford, she, along with her students, litigate live cases before the U.S. Supreme Court. The list of cases in which Professor Karlan has represented either the petitioner, respondent, or amicus before the U.S. Supreme Court is far too long to detail, but reads basically like our syllabi here at the law school. Counsel for the respondent in United States versus Windsor. Counsel for the United States as amicus in Obergefell versus Hodges. Counsel for petitioners in Herring versus U.S., Cohn versus Bell, Kennedy versus Louisiana. Counsel for Amici in Lawrence versus Texas, Gruder versus Bollinger, Hamden versus Rumsfeld, Casey versus Planned Parenthood, and the list goes on and on. Not surprisingly, in 2016, she was named one of the Politico 50, a group of thinkers, doers, and visionaries transforming American politics. We are very fortunate to have her here today with us. It's a great honor to introduce to you Professor Pamela Carmen.
Thanks so much for inviting me, and a special thanks to Carolyn Spalding for actually getting me here. It was a shock to me to find out that she's a student here at the law school, because I thought she was an administrator who handled travel details for the university from what she's done, so I'm incredibly grateful to her. It's an special honor to be here with so many people from whose work I've learned so much over the years and who I've gotten to work with. And I know I'm going to come away from the symposium with both some new questions and some new answers. And I was jotting down a whole lot of stuff during the first panel that I'm going to try to incorporate into the written version of what I'm going to talk about with you today. And congratulations, obviously, to all of the folks at Missouri for their prescience in having set up this conference before so many of the most recent and most interesting developments. So in the famous footnote 4 of Caroline Products, the Supreme Court identified two categories of laws that should be subjected to more exacting judicial scrutiny than laws normally get from the courts. Both of those categories centered on defects in what the court called the political processes by which individuals and groups are normally expected to protect their interests. The first category of these laws that might call for some kind of special scrutiny were those laws that, in the court's words, restricted the political process itself. And here, not surprisingly, the court's prime example of laws that call for this kind of heightened scrutiny were restrictions on the right to vote. The second category of laws that the court identified were those that targeted discrete and insular minorities against whom what the court called prejudice had curtailed the operations of the normal political process. Now in Kramer against Union Free School District, the Supreme Court gave teeth to Caroline Product's suggestion about how you should think about these laws. That was a case about a law that denied people the right to vote in school board elections unless they either owned property in the district or had school children in the district. So even if you were otherwise a registered voter, you couldn't vote in those elections. And in striking down that law, Chief Justice Warren's opinion for the court that explained that because the right to exercise the franchise in a free and unimpaired manner is preservative of other basic civil and political rights, any infringement of the right of citizens to vote must be carefully and meticulously scrutinized. And he warned that unjustified discrimination in determining who could participate in political affairs undermines the legitimacy of representative government. Accordingly, rather than applying the normal deferential form of rationality review that normally governs judicial determinations of constitutionality, courts faced with restrictions on the franchise had to, and here I'm going to quote from the court, determine whether the exclusions are necessary to promote a compelling state interest. And even today, after a series of cases that have moved towards what the court has called a more flexible approach to merely regulatory provisions, something that's made it difficult to challenge a number of the other kinds of restrictions on the right to vote, like voter ID and the like, strict scrutiny remains, according to the court, the appropriate standard for severe burdens, such as outright disqualification from the right to vote at all. Now, those of you who have studied the issue of disenfranchisement of people who've been convicted may wonder why I'm telling you any of this. I mean, I think Jack is probably wondering even more than everybody else. Because while one might think that laws that disenfranchise people because they've been convicted of a crime should get hyper strict scrutiny because they lie at the intersection of the two justifications, right? They are restrictions on the right to vote, and those are supposed to be strictly scrutinized, and they're restrictions that affect a group of people who are discrete and insular and are the subject of a great deal of prejudice. So you might think this is the area where of all areas there should be strict scrutiny on the right to vote. 5 years after Kramer, the Supreme Court wiped out that idea completely in a case you've heard a little bit about already. That case is Richardson against Ramirez. And the Supreme Court in Richardson against Ramirez held that Section 2 of the 14th Amendment, which contains something called the Restriction of Representation Clause, which says essentially that if a state denies any of its male citizens over the age of 21 the right to vote except for conviction of a crime or participation in rebellion, what the Supreme Court did is it read that provision to say that there was an affirmative sanction on disenfranchising people because they've been convicted of a crime. And of course, the ironic thing about that is the whole reason the Reduction of Representation Clause was put into the 14th Amendment was that Congress was worried that black people would be disenfranchised in the South. Right? So there's this huge irony that a clause that was put in to prevent the disenfranchisement of African Americans has been one of the most powerful tools for disenfranchising them in modern times. And the ironic consequence of this is that while the 15th Amendment, which comes after the 14th Amendment, that's where Jack has done, I think, some of his most interesting work on these issues, and saying the 15th Amendment really kind of supersedes the Reduction of Representation Clause. But the ironic consequence is while the 15th Amendment enfranchised slightly shy of 1 million African Americans in 1870, and I figured this number out by figuring out how many African American men were there in the United States over the age of 21, and that's about the number. So the 15th Amendment enfranchised about 1 million black men in 1870. Offender disenfranchisement laws today disenfranchise more black men than that. Right? So silently, we've done exactly the opposite of the 15th Amendment. The reason, so you might wonder, why did I bother telling you about strict scrutiny at all, given that it's not going to apply to the problem we're going to be talking about today? And the reason I began by describing strict scrutiny and process theory is because the story of offender reenfranchisement raises an arresting question for that most influential and foundational theory. And it's a question that I should never have mentioned to Bruce in the car coming down here, so he stole my thunder on this. But the point is this: efforts to gain reenfranchisement through the courts have been strikingly unsuccessful. The few successful attacks, think for example of Hunter against Underwood or McLaughlin against City of Canton, have involved smoking gun evidence that the specific list of disenfranchising crimes is the product of outright racism. Indeed, even outright racism is not enough. Jesse told you about this in the last panel with regard to Florida's old law, and Myrna talked about this as well. But consider another example, the Fifth Circuit's opinion in Cotton against Fordyce, which upheld a Mississippi constitutional provision that disenfranchised anyone convicted of the following list of crimes: murder, rape, bribery, theft, arson, obtaining money or goods under false pretenses, perjury, forgery, embezzlement, or bigamy. The Court of Appeals recognized that this provision had its origins in the Mississippi infamous Constitution of 1890, whose central purpose, according to the contemporaneous explanation of the Mississippi Supreme Court itself, was, and here I'm going to quote the Mississippi Supreme Court saying, this is what we're trying to do: obstruct the exercise of suffrage by the Negro race. And the Fifth Circuit recognized that the provision in front of it was part of that Constitution and served that purpose. But it held that that purposeful discrimination was not enough to doom the exclusion, because the provision had overcome what the court recognized were its odious origins by being reenacted in a process that added murder and rape to the original list. And the Court of Appeals helpfully explained, without noticing that there was something kind of sick about this, that these were crimes, according to the Court of Appeals, that were, quote, historically excluded from the list because they were not considered black crimes. So by adding these two additional crimes, they had somewhat whitewashed all of the previous racism. And after a few interim successes, the challenges to offender enfranchisement brought under the Voting Rights Act ultimately failed as well, despite the staggering evidence of the practice's disparate impact on black communities. And you heard in the previous panel the question of, if you were actually a textualist, how could you say what any of these courts had said? By contrast, we've seen real progress towards restoration within the political system. All of it achieved, obviously, without the votes of disenfranchised people. That's the whole point, is it's one of those things that people who already can vote made the decision for the people who can't. And this divergence is not just a modern phenomenon. It goes back at least to the time of Richardson against Ramirez itself. In front of the Supreme Court, then Secretary of State Jerry Brown, who's just stepped down as the governor, filed a brief supporting the challenge to the state's disenfranchising laws, based on what he said was the utter unrelatedness to any state interest of disenfranchising people for life. And less than 6 months after the Supreme Court upheld the California Constitution that contained a lifetime ban, California voters replaced that challenge provision, which had originally provided that no person convicted of any infamous crime shall ever exercise the privileges of an elector in this state, with one dictating only that the legislature should provide for the disqualification of electors while in prison or on parole for conviction of a felony. And as you've seen already, over the last several decades, 24 states have changed their policies to offer more opportunities for restoration. Some of these states have repealed lifetime disenfranchisement laws. Others have liberalized the procedures for individuals to recover their right to vote after they complete their sentences. And Florida's Amendment 4 and its distressing aftermath, which I imagine will be part of our focus here, is only the most recent development at the state level. And as you also just saw, at the federal level, the Democrats included in H.R. 1, the first piece of legislation they proposed when they took over the House of Representatives earlier this year, a Democracy Restoration Act, designed to ensure that the right of an individual who's a citizen of the United States to vote in any election for federal office shall not be denied or abridged because that individual has been convicted of a criminal offense unless such individual is serving a felony sentence in a correctional institution or facility at the time of election. And one of the groups of people who don't get mentioned quite enough, but really should, are the number of people who are incarcerated on election day who've been convicted of no crime. People who can't make bail. And those people in many states are denied the right to vote because no state no state is required as a matter of constitutional law to ensure that people get absentee ballots if they're incarcerated. There's an old Supreme Court case that suggests states can decide for themselves what kind of absentee ballot rules to have. So if you live in a state that doesn't have no excuses absentee ballots and doesn't allow people, doesn't think that incarceration on election day is a reason to give you a ballot, you can't get a ballot on election day. And these are people who've been convicted of no crime. And I think one of the things, and this ties into something that Bruce Kane said on the earlier panel that's important to understand, is the extent to which laws that disenfranchise people because of conviction of a crime result not just in the disenfranchisement of people convicted of a crime, but a whole range of other people. And in Florida, we saw this most powerfully in the 2000 election, which was decided, you may remember, at the presidential level by 537 votes, or more accurately decided ultimately by one vote at the Supreme Court. Thousands of people were knocked off the rolls in Florida by a purge process designed to remove offenders from the rolls that tried to match the names of people to offenders' names. And if you have a name like George Brown, you know, I guarantee you there's somebody in America who's disenfranchised because their name is George Brown. There's some felon who's in serving time whose name is George Brown, and the chances of matching the names was huge. And one of the studies done after the Florida election showed that there were 4,000 people who were struck off the rolls in Florida who later got back on the rolls who had never committed any offense, which dwarfs the 537 votes by which the election was decided. So these laws don't just deal with people who are actually serving time. They deal with a wide range of individuals being disenfranchised who couldn't possibly be disenfranchised under the law itself, but get de facto disenfranchisement of the kind that Myrna was talking about. It turns out, and this is part of why I talked about process theory at the beginning though, that reenfranchisement is only the most recent illustration of a more general point about the law of democracy. And that point is that many, if not most, of the significant gains in enfranchisement have been the product of what Justice Felix Frankfurter memorably called an aroused popular conscience searing the conscience of the people's representatives, which I know starts to look now like a panini. You know, you should see the sear lines on the conscience. But it's true. For example, in the 5 years after the Voting Rights Act of 1965 was passed, executive enforcement efforts involving federal registrars and voting examiners led to nearly as many African Americans registering to vote in 6 southern states as had registered in the century since the 15th Amendment had been ratified. And Section 5 of the Voting Rights Act, which you heard reference to its demise in the previous panel, was in President Johnson's words, one of the most monumental laws in the entire history of American freedom, precisely because it relied on administrative preclearance rather than litigation, and thereby shifted the advantage of time and inertia from the perpetrators of disenfranchisement and dilution to its victims. The recent progress on restoration challenges the conventional understanding of process theory and judicial review in another way as well. The 21st century has seen the emergence of what Professor Dan Takagi named the new vote denial, and you heard a number of references to this on the previous panel as well. Recent years have seen the enactment of draconian voter ID laws, cutbacks to early voting and same-day voter registration, and a variety of other measures that make it harder to register, to cast a ballot, and to have that ballot counted. Some of those measures have been enacted by the very states that have been easing the exclusion of people convicted of crimes. What might explain the counter-cyclical headway being made on reintegration of former offenders into the political community, even as other long marginalized groups face new barriers? To drill down on these questions requires us, I think, to see how restoration plays into what I've described in earlier scholarship as the tripartite nature of the right to vote. Voting embodies 3 nested concepts. The first of these is participation. That's the right to cast a ballot and to have that ballot counted. That right really can be thought of as an individual right, and I'll return to it in a moment. The second interest is what I call aggregation, which is the ability to join with like-minded voters to achieve the election of your preferred candidates. This is, almost by definition, a group right. Groups of people elect representatives, individual people don't. And the third of these interests is the interest in governance, the ability to achieve your preferred policies through representative decision making. What I'm going to suggest to you today is that the restoration movement involves all three of these, and its progress and the resistance to that progress reflect how these concepts interact with each other. So let's start with participation. The right to vote serves a powerful expressive function regardless of election outcomes. Over our history, the franchise has been used to delineate who is and who is not a full member of the community capable of rational self-governance as well as group communal governance. Or as Justice Albie Sachs of the South African Constitutional Court put it, and he was a man who not coincidentally spent quite a bit of time in prison during the apartheid era, he framed it this way. He said, the vote of each and every citizen is a badge of dignity and of personhood. Quite literally, it says that everybody counts. In a country of great disparities of wealth and power, it declares that whoever we are, rich or poor, exalted or disgraced, we all belong to the same democratic nation, that our destinies are intertwined in a single interactive polity. On this account of what voting is about, the lumping together in the past of aliens, insane persons, and illiterates with criminal offenders made an important statement. And those were the groups that were put together in the law that Afran Ramirez challenged in the Supreme Court. Each of these groups is seen as outsiders or otherwise unfit to take part in the process of government. Moreover, offender disenfranchisement rested on a social contractarian notion that those who are going to be bound by the laws should have some say in what the laws are. The disenfranchisement of offenders on this account reflects the idea that those who fail to abide by the law that was democratically enacted have broken their side of the social contract. As Judge Henry Friendly put it, a man who breaks the laws he has authorized his agent to make for his own governance could fairly be thought to have abandoned the right to participate in further administering this compact. So what's broken down over the past several years that makes that expressive notion and the way we treat the question of participation change? And change it has. So at the time, Chief Justice Warren was announcing strict scrutiny for most restrictions on the right to vote. Even Chief Justice Warren didn't think, and I think he did this almost unthinkingly, that restrictions on the right to vote for former offenders would violate the Constitution. So the Supreme Court had before it a case called Trump against Dulles, where the court held that stripping a person of his citizenship violates the Eighth Amendment. It's cruel and unusual punishment to strip somebody who was born an American citizen of his citizenship. The court has always allowed you to strip naturalized citizens of their citizenship if, for example, they lied in the naturalization process. But if you were born an American citizen, the Supreme Court said it is a violation of the prohibition on cruel and unusual punishment to take that away. And the court said that essentially taking away somebody's citizenship is a form of punishment more primitive than torture, for it destroys for the individual the political existence that was centuries in development. And what was striking about that case is, right after saying that, the Supreme Court said, so taking away somebody's citizenship, that is clearly cruel and unusual punishment. But taking away their right to vote was nothing more than designating a reasonable ground of eligibility for voting. It was a non-penal exercise of the power to regulate the franchise. And one of the things I want to think that has changed, and there's a kind of irony in this, is the more you hear screaming and yelling about how we need voter ID laws and the like to prevent non-citizens from voting, the more it ties together in the public mind the idea that, of course, citizens can vote. And that if you take away somebody's vote, you are in essence taking away a central part of their citizenship. Now, no one in public discourse today defends the idea that we are disenfranchising people who've been convicted of a crime for regulatory reasons. No one thinks that we are doing it to rehabilitate them. It can't rehabilitate you to deny you the right to vote forever. No one thinks that it is incapacitating you from doing something wrong, because the idea that you need to deny people who've been convicted of a crime the right to vote in order to prevent election fraud beggars belief, and no one makes that argument. The one place where you see that is that people who committed election fraud should be denied the right to vote in the future. And I think even people who normally would be against disenfranchisement might be totally comfortable with that. That is, if you've shown that you want to engage in fraud in the election process, we have to prevent you from engaging in fraud in the election process, and the only way to do that is prevent you from voting. Everybody now, if they justify this at all, justifies it entirely as retributive. And therefore, it makes it even clearer that it's punishment, and punishment that should be at least subjected to Eighth Amendment standards. And this is where I think one aspect of governance, of representative decision-making, begins to bleed back, if you will, into the arguments about participation. Think here about the recent passage of the First Step Act at the federal level, or California's realignment decisions about whether people should be sent to prison, or decriminalization of various drug-related activities all across the country. Each of these developments reflects a growing public conviction that we are branding too many people as criminals and inflicting far too severe consequences on even those people who break the law and do deserve some punishment. And here, I can't help wondering whether part of what was driving Richardson against Ramirez, in addition to the textual issue, was that Richardson against Ramirez was decided by the Supreme Court at a time when there was really a decent argument that we weren't tough enough on crime. Because at that point, the United States was at the peak of some of its crime rates and at the nadir of some of its imprisonment rates. Whereas today, we're actually at the opposite. We imprison more and more people even though the crime rates have been going down. The revitalization in public discourse of rehabilitative and redemptive functions of punishment and of rehabilitative and redemptive approaches to people who've been convicted of crime after its rejection during the 1980s in favor of retribution and deterrence feeds into the restoration movement. The rhetoric of the movement focuses on giving individuals who have paid their debt to society, which is expressly contractarian language, the ability to reintegrate themselves. And restoration is a largely costless and heavily symbolic way to signal that reentry. Unlike the other kinds of programs that we might have to actually ensure the reentry and reintegration of people who've been convicted of crimes, this one actually doesn't cost any money at all. It's actually probably cheaper because you can administer the election systems better. And as was noted on the previous panel, the U.S. restoration movement has not yet really pressed to enfranchise incarcerated citizens, despite the fact that nations from Canada to South Africa to Germany to Israel do exactly that. Now let's step back for a moment to ask a little more about the new vote denial. It's striking that the share of Americans who support restoration, roughly 2/3 of likely voters, is virtually identical to the share of likely voters who think citizens should be required to show photo ID at the polls before casting a ballot. And the number of citizens who are effectively barred from voting as a result, like the number of citizens who are convicted of offenses that disqualify them from voting, numbers in roughly the same millions, more or less. So what accounts for the coincident rise of voter ID laws and the decline in the severity of offender disenfranchisement provisions? Well, one factor is surely the lack of a consequentialist argument for offender disenfranchisement. We no longer think, if we ever really did, that offender disenfranchisement protects against vote fraud, or that it deters people from committing crimes. Because most of the people who commit crimes commit their first offense before they've ever voted, because young people vote at such low rates, and young people are the primary people convicted of crimes. By contrast, the narrative of voter ID is almost entirely driven by claims, specious claims, that it somehow presents a real risk of fraud. And this goes back into what Jesse was saying about solutions in search of a problem. And honestly, if people were more candid about it, they'd say the problem that this is a solution to is a change in the overall composition of the electorate that has partisan consequences. In addition, the narrative of personal responsibility seems to play out differently with respect to offender disenfranchisement and voter ID. It's striking that much of the recent public attention has involved challenges to state restoration procedures that place too complex or too difficult a hurdle in the path of people seeking to regain their voting rights. By contrast, Many courts and most Americans seem to think that obtaining a government-issued photo ID is sufficiently easy that it's reasonable to expect every aspiring voter to get one. And I think part of the challenge that we face as litigators is educating the courts on exactly how difficult both of these sets of hurdles are. How many people in this room don't have a currently issued currently valid government-issued photo ID? How many of you had trouble getting one? You are lucky people indeed, because there are millions of Americans for whom this is extraordinarily difficult. It's difficult because, for example, they were born at home and they don't have a birth certificate. Or it's difficult, my favorite example from the Indiana voter ID case was an 80-year-old woman who showed up with her birth certificate, and what do you think was different about her birth certificate than her name? She got married. And so they said, come back with a copy of your marriage license. And if you do, where do you get most voter ID, where do you get most government-issued photo IDs? The DMV. What kind of people go to the DMV? People with cars. So if you don't have a car, you might not want to get a driver's license. And even if you wanted to, you might find it difficult to get there. We actually, in one of the cases I worked on, we had statisticians figure out how long would it take by public transportation to go to the nearest DMV office. And in a lot of places, it can be 3 or 4 hours. Or you can have people who can't get their birth certificates because they don't have the money for it. One of the most moving moments in the entire Texas voter ID case was when we put a woman on the stand who said, Texas said they'd give me a free ID if I could get my Mississippi birth certificate. Mississippi wanted $42 for the birth certificate. I get $324 of cash a month to feed myself and my children. And you know what? My children can't eat a birth certificate. So I had to wait. So for those people, it's really a hurdle to do something that might be very easy for all of us. And the same thing is true for a number of people seeking re-enfranchisement. That showing that they've paid the fines and fees, let alone paying the fines and fees, puts a real tax on them, whether you call it a tax or not. But the most striking difference, I think, that explains some of what's going on in the space of re-enfranchisement seems to be the acoustic separation of participation and aggregation arguments in the discussions around re-enfranchisement. There's widespread bipartisan support for one or another form of re-entry. Consider one list the Brennan Center put together of people who support allowing people who've been convicted of a crime to vote at some point after their conviction. It includes Lindsey Graham, that great man of principle, Rick Santorum, Orrin Hatch, Rand Paul, and George W. Bush, along with the Koch brothers. Or look at the recent results in Florida with respect to Amendment 4. Republicans won both the gubernatorial race and the senatorial race in Florida by razor-thin margins. And yet, nearly 65% of voters supported offender restoration. Just doing the math, then, reveals that a significant number of Republican-leaning voters, at least a third of them, must have voted for restoration. And the aftermath in Florida offers a powerful illustration of how the treatment of voting rights becomes more polarized once aggregation issues enter the picture. Offender restoration raises the prospect that more than 1.4 million Floridians can now join the voting rolls. Most social scientists who study the issue assume that turnout rates and candidate preferences among newly re-enfranchised people convicted of a crime are likely to resemble the turnout rates and candidate preferences of otherwise demographically similar components of the electorate. That maybe that even sends an upper bound on turnout. Poor people, less well-educated people, members of racial minorities tend to turn out at lower rates than more affluent, white, educated voters. And that's true pretty much everywhere in the country. But that doesn't mean that nobody will turn out. And even if only a small fraction of former offenders actually vote, their votes can well swing elections in any state where margins of victory have been razor thin. Florida being one of those states. And politicians quite understandably assume that a group of voters who are disproportionately non-white, as the offender population is, disproportionately low income, as the former offender population is, and disproportionately less well educated, are more likely to increase the share of votes going to Democratic candidates. So it's not surprising, even if it is depressing, that the Republican-controlled Florida state legislature has proposed implementing legislation for Amendment 4 that would restrict reenfranchisement to former offenders who've paid off a variety of fines and fees. And Florida has the second highest number in the country of types of fees and court surcharges. I'm sure I'll look forward to the Brennan Center's next day, which will figure out just what proportion of people are going to be barred by the fines and fees provisions that are no longer barred by outright disenfranchisement. And these fines and fee provisions and the like, in a sense, may come to resemble voter ID procedures, where less affluent citizens are put to the choice between paying the government in order to exercise their right to vote or paying to put food on the table. The divergence between popular support and politician resistance resembles yet another issue in voting rights, which is term limits. Nearly all term limits legislation in the country has been imposed through direct democracy rather than through ordinary legislation. And the same is true for the reemergence of independent redistricting commissions, where the support doesn't seem to be super partisan, and even in a time where political polarization has been solidifying. These are quite popular among the general public. And this returns us to the first prong of the political process theory that I started off talking about. The concern that, in John Hart Ely's words, the ins are choking off the channels of political change to ensure that they will stay in and the outs will stay out. What we might call the problem of entrenchment. That professional politicians would prefer to restrict the franchise to an electorate in front of which they've already won an election is entirely predictable. Because you know the people who were voting in the election you won are an electorate you can win in front of. Any other electorate introduces some uncertainty into that. Now, the effects of disenfranchisement and restoration on electoral outcomes may turn out, oddly enough, to be most salient at the statewide level precisely because of another aggregative issue. The longstanding requirement under the Voting Rights Act for the creation of safe majority-minority districts, along with a demographic phenomenon that people refer to as the big sort. For years, activists like Peter Wagner have been pointing out that one consequence of our current system, which largely counts prisoners where they are incarcerated, rather than in the communities where they live and to which they are likely to return, is that political power gets allocated away from urban, heavily minority communities towards the rural jurisdictions where states tend to locate their prisons. Offender reenfranchisement standing alone will not alter that fact. The population base that will determine whether a particular apportionment satisfies one person, one vote will remain unchanged. And thus, reenfranchised voters may end up being concentrated in districts that already elect local officials, state legislators, and often even members of Congress that already reflect the party preferences of the reenfranchised. So take Florida as an example here. In 2018, the margin of victory for the Republican candidates for governor and senator were 32,463 votes and 10,033 votes respectively. It's easy to see how reenfranchising people after they've finished their sentences could swamp those margins, right? Because we have potentially 1.4 million voters. But now, look at Florida's 27 seats in the House of Representatives. In only one of those districts, in only one of the 27 districts, was the margin of victory less than 10,000 votes. And in only 3 additional districts was the margin of victory less than 40,000 votes. By contrast, 5 districts were not even contested by the Republican Party, and several of those districts are heavily African American. So the reenfranchisement may not make any difference in those elections because the districts are already safe seats for one party or the other, and no amount of reenfranchising people is going to change that. Unless they all decide to move to some part of the state that they never would have moved to before, and it's hard to imagine that when you think about where some of these places are. So it may turn out that the 2 areas where restoration has the biggest direct electoral consequences are statewide elections, where there can't be any districting, and where a number of states are battleground states, or direct democracy, the 2 aspects of the political process where aggregation rules have the least impact. They can have some impact. For example, the 60% rule in Florida for constitutional amendments means that 42% of the people can beat 58% of the people every time. But there aren't a lot of rules, other than supermajority rules, that affect aggregation at a kind of at-large level. Finally, let's return to voting as governance. As I suggested earlier, the current push for re-enfranchisement and restoration did not arise in a vacuum. Although every public discussion of offender disenfranchisement trots out statistics about the huge increase in the number of people disenfranchised by such laws, and about the staggering percentage of the African American community that is directly excluded. Those statistics tap into concerns about over-criminalization, over-incarceration, and over-policing as straight-up matters of criminal justice policy. In other words, once you start thinking about criminal justice policy differently, this concern about disenfranchising people because they have had interactions with the criminal justice system is going to change as well. And once support began to grow for the idea that we criminalize too much conduct, prosecute too many people, and punish people too severely, we can start to look at many aspects of offender disenfranchisement with a fresh eye. Consider one of those issues that is only starting to be on the table, the question of should incarcerated people be entitled to vote. When I've raised that issue with my students, and I point out that in many of our counterpart democracies, even prisoners can cast a ballot, one of the most striking examples for me is in Israel, the man who assassinated Prime Minister Rabin is allowed to vote in Israeli elections. I get two responses from the students when I talk about, well, what should we do about people who are still incarcerated? The first of these is that depriving someone of his voting rights while he is in prison is just part and parcel of the punishment. There's a lot of stuff people can't do when they're locked up, and that's in fact part of the point of locking them up. Ironically, though, the more important the right to vote is, the more denying it to people might be potentially justifiable as a form of punishment, or at least as deterrence. If we really thought that denying you the right to vote while you were in jail led people not to commit crimes that sent them to jail, that would be a wonderfully low cost and a deterrent. Of course, nobody believes that it actually deters because criminals are not rational in quite that way. If you're not going to be deterred by being locked up in a cell, the likelihood that you're going to say, well, but if you lock me up in a cell and you don't let me vote, I'm not going to commit the crime, seems kind of low. I mean, I guess it prevents those of us who teach election law from doing this. Although I have to say, every time I go to see one of my clients in prison, I vow I'm never going to commit any crime again, not even crossing against the light, driving 52 in a 50-mile-an-hour zone. I don't even want to drive for weeks afterward, lest I commit some traffic offense. But the second response that the students give me rests on the United States' distinctive form of aggregation for electing a huge percentage of our offices, which is we use geographic single-member districts to elect those offices, from school boards to city councils to state legislatures. Where, my students ask, should incarcerated people be permitted to vote? If they're permitted to vote where they're housed on election day, which is where the census counts a huge number of them, there's the possibility, particularly in local elections, that almost the entirety of particular districts will be made up of incarcerated individuals. For example, if the prisoners in Louisiana were permitted to vote for members of the Iberville Parish School Board, then one of the board's districts would have contained only 2 eligible voters. That is 2 people living in the community, because so many people live in the prison, and the districts are relatively small because it's a local election. And this might have 2 separate and troubling consequences. Either people who are in prison won't vote because they have no interest in the local school board election, since their children are not going to those schools and the like, and it's an election that has issues that concern them not at all. And what that would do would be to give disproportionate weight to the 2 people living right outside the prison walls relative to the other voters in the district, right? I mean, it's basically, if you think about it, they're like North Dakota in the Senate. Or the prisoners will vote in these elections, and the votes of people with no ties to that particular local community will outweigh the votes of people who actually have to live with the consequences of representative decision-making. So if people can vote where they're in prison, there's a problem. So let's suppose that states abandon what Peter Wagner has aptly termed prison gerrymandering. Then those individuals could vote from their pre-incarceration addresses. Notice something about that solution. It rests on the proposition that incarcerated individuals remain part of the community from which they came, with ongoing ties to that community, and with intentions to return there. Those assumptions, I want to suggest, are at least somewhat inversely correlated to the length of their incarceration. I think we can reasonably assume that somebody who's serving a one-year sentence retains those ties. There's actually no necessary difference between him and one of us who takes an academic visiting year position out of state and across the country. But those assumptions might begin to break down as a prisoner starts to resemble Rip Van Winkle, absent for decades from a community that may have changed profoundly in the interim. But even here, I think it's worth recognizing how prisoner voting might fit into the larger ecosystem of rules governing the franchise. So one question we might ask ourselves is whether incarcerated voters, incarcerated citizens, differ in some salient way from overseas voters and overseas citizens. Because under UOCAVA, one of the less studied provisions of federal voting law, for example, U.S. citizens who move overseas can continue to vote in federal elections by absentee vote in their last place of residence in the United States, so long as they would otherwise be qualified to vote under the laws of the jurisdiction where they last resided. Many UOCAVA voters, including some whom I represented as an amicus in the Supreme Court, are real expatriates. I mean, they live overseas. They do not have a house in the United States anymore. They have children born overseas. They have grandchildren who've been born overseas. And yet we permit their subjective sense of continuing ties to the United States to determine whether we will allow them to vote. And it's not clear that prisoners, even if they're serving long sentences, are any different from those people. But this also ties in to issues about governance. In upholding New York's then existing lifetime disenfranchisement regime against a challenge brought ironically enough by a man who was convicted under the Smith Act, basically for being a communist and believing in the violent overthrow of our government, Judge Henry Friendly wrote that it could scarcely be deemed unreasonable for a state to decide that perpetrators of serious crimes shall not take part in electing the legislators who make the laws, the executives who enforce these, the prosecutors who must try them for further violations, or the judges who are to consider their cases. A contention that the Equal Protection Clause requires New York to allow convicted mafiosi to vote for district attorneys or judges would not only be without merit, but as obviously so as anything could be. But if society comes to understand, as I think we are, that many of the individuals who were excluded did not commit serious crimes, and that there are very real arguments about whether the laws under which they were convicted should lead to incarceration or other civic disabilities, then it might come to believe as well that the ability to participate in changing those laws going forward is actually quite important. New York's savagely punitive Rockefeller-era drug laws were maintained for many years by a state legislature whose overall composition was a product of prison gerrymandering. And in the penultimate decennial reapportionment before New York started reassigning incarcerated persons to their free world addresses, 7 New York State Senate districts, many of them represented by the state's most draconian legislators, met constitutional population requirements only by including prisoners. So if we start sending people to prison for less time, the argument that they shouldn't continue to vote where they're coming from loses any of its traction at all. And one question we've only recently begun to consider, particularly because of the savvy strategic decision of restoration advocates to focus on participation rather than on aggregation or governance, is to what extent changing the composition of the electorate by re-enfranchising some proportion of people who have been convicted of crime will change criminal justice policies going forward. Or perhaps even more broadly, will re-enfranchisement change policies regarding the school-to-prison pipeline? Or will it change policies regarding how we treat people while they're incarcerated? Or even more provocatively, if you've read my colleague John Donahue's 2001 article, The Impact of Legalized Abortion on Crime, will it change the regulation of reproductive autonomy? It's too early to tell, but 2020 may give us a first window into answering those questions about whether the change in the electorate will change policy going forward. Here are just a few of the things I'll be watching for. What will the actual turnout effects of reenfranchisement be? Will reenfranchisement have outcome effects in battleground states like Florida or Virginia? Will reattribution of incarcerated persons in the states that have adopted that policy change the composition or the partisan makeup of state legislatures? Will arguments about procedural hurdles to reenfranchisement spill over into and inform other areas of the new vote denial? Will we move towards national resolution of the question of vote restoration, or will it remain a state-by-state process? And finally, will offender restoration remain a consequence of criminal justice reform, or will it be a cause of future reform? Thank you very much.
I think we have time for some questions.
Great. So any questions, or do I just start cold calling on people? I mean, I can also, yeah, sorry.
When you talk about the effects, you're talking about a smaller part of the population, and you're talking about the differential as to whether they will in fact have a unified view or not. And how are you going to be able to measure that?
So there are social science techniques for trying to figure out the voting preferences of particular groups by looking at, I mean, there are a variety of different techniques for doing this. Most of them involve taking census data and matching it up with election returns on a precinct by precinct basis, and then looking at how changes in the composition of particular precincts along whichever demographic you're interested in map onto changes in election preferences. Am I getting that right, Bruce, Emily? More or less? I mean, at a relatively high level of generality. Because this is what you learn as a lawyer is how to work with the experts who actually do this rather than doing it yourself. But, so for example, if in precincts where, where there are a disproportionate number of African Americans, candidate A gets more votes than candidate B, and vice versa in other precincts, you can infer something about the individual behavior, in a sense, from the group behavior. So the people who've done the most work on this in offender, with regard to people convicted of crimes and offender disenfranchisement, are Jeff Uggen and Chris Manza, or is it
Yep.
Jeff Manza and Chris Uggen? And what they did is they did some estimates taking, for example, saying, do we have a reason to believe that there would be a huge difference in the voting behavior of two people who are otherwise identical based on whether one of them had been convicted of a crime in the past? And they make, I think, what's a realistic assumption that there's not going to be a huge difference in the partisan valence there. That is, if most people who are 45 years old, black, and have been convicted of a crime, vote for the Democratic Party, and have not been convicted of a crime, vote for the Democratic Party. The same thing is likely to be true of 45-year-old black males living in that same city who have been. So that allows us to then say, well, what percentage of people who are otherwise like people who've been convicted of a crime along whatever the demographics we want, our homeowner, and the census gives you so much information, you can break this down in all sorts of interesting ways. What percentage of those people are voting? And not surprisingly, for a lot of those groups, it's a relatively low percentage. So I think in some of their work, Uggen and Manza have assumed that the turnout rate among former offenders who've been reenfranchised might only be 15% in a lot of elections. But that 15%, if the margin of victory between the two parties is 1% and felons break 10%, break 2 to 1 in favor of one of the candidates, can switch the vote. So is that responsive to your question?
Yeah, it does seem to me that it might be so small that it doesn't matter.
It will be so small it doesn't matter in any place where the turnout among former offenders, the turnout among the reenfranchised is low, and the margin of victory is great, or where the relative behavior of people convicted of crime is quite close together between the two candidates, and the margin's bigger than that. So that's why I said, for example, I don't think that any amount of reenfranchisement in Florida is going to dramatically change the fact that of the 27 congressional districts, at least 20 of those districts are going to be safe districts, either for the Democrats or the Republicans, unless like a huge number of people, as they're being let out of prison, say, let's all move to place X. Yeah.
So one thing that is very real right now is that there is a lot of C3 and C4 money that is going into registering folks who are now in franchise. So I think Florida is going to be a very interesting test on whether or not those old statistics hold in the face of a massive intervention and campaign that is specifically targeted toward converting those folks. And so like I think it will test the way we register, it'll test the effect of money. I think it's gonna test a lot of this stuff. Really.
Yeah, I mean, and the question will be, what will the upper boundary be on
Right.
that? Both in terms of how you get them registered and then what's their turnout. And then the other thing is people turn out very differentially based on how meaningful the election is. So in states that are battleground states, in races that look close, turnout tends to go up relative to safe districts. In states that hold some of their, you know, one of the problems in the United States, and this has nothing to do with disenfranchisement directly, is we hold way too many elections. That is, in a lot of countries, there's one election day every couple of years, and all of the focus goes to that. In California, you know, there are like random days in June where they hold an election for reasons that are obscure to me. They put major ballot propositions on an election day for a primary election, and there are no contested primary races of any meaningful nature for the party I'm affiliated with. You know, if it weren't for the fact that I have this mystical belief that I have to vote in every election, there are a bunch of elections I might miss. And so there are all of these questions about that part of our election system that, you know, we may get some really interesting information about. A point that I've made for many years, which is almost every other democracy in the world, the government takes the responsibility for registering the citizens. And that's one of the major reasons why turnout is higher, is, you know, Canada, before they went to a computerized system for this, sent door-to-door canvassers paid by the government to every house in Canada to see whether the people who lived in that house were registered to vote. The United States takes exactly the opposite position on this. The burden is put almost entirely on the individuals. I mean, some states have started to change this with automatic voter registration. But, you know, until 1984, Virginia had a law that made it a felony for the county clerk to encourage anyone to register. Right? So you know, this question of what the turnout will be and how that turnout and the margin within that new turnout will map onto the existing divide is an empirical question that can be answered. What the answer will be is what we'll see. Other questions? I've stunned you all into silence. You're thinking about lunch.
Well, the Eighth Amendment argument came up earlier, and I wonder if you have sort of thoughts about that and want to kind of explain. I mean, with the exception of immigration and some recent sex offender cases, collateral consequences generally, and you mentioned Trump v. Dulles, but I wonder if you think the Eighth Amendment argument that has any.
Yeah, so I tried to make the Eighth Amendment argument in an earlier piece of scholarship. The Eighth Amendment prohibits cruel and unusual punishment, and the question is disenfranchising someone or disenfranchising someone for life cruel and unusual punishment. And the Supreme Court in Trump against Dulles, and going forward really until about a week and a half ago, when Justice Gorsuch issued his first opinion along these lines, has taken the position that the way we determine whether a punishment is cruel or unusual, they take a twofold approach. One is they say you don't look back to 1789. Instead, we have evolving standards of decency. So things that might have been okay in 1879, like hanging people to execute them, we generally think violate the law, violate the Constitution today. In 1789, I mean, there's an actual separate opinion by Justice Thomas that suggests because in 1789 at common law you could execute 7-year-old children, it wouldn't be cruel and unusual to execute a 7-year-old today. You know, every felony was punishable by capital punishment in 1789. Today, the Supreme Court has held really a felony that does not result in the death of a human being cannot be punished by execution. That was in part what the Kennedy against Louisiana case that we litigated a couple of years back said. So that's the first thing, is evolving standards. And the second thing is that the Supreme Court, in trying to figure out whether punishment is cruel or unusual, looks to what the practice is in the states at the time. So In Kennedy against Louisiana, we showed that by the time of that case went to the Supreme Court, it was a case about whether rape of a child could justify executing the person convicted of the rape. There were only 4 states that did this, and so the Supreme Court has done a kind of nose counting as part of the way it thinks about things. So that's the second piece of the Eighth Amendment. The third piece of the Eighth Amendment is that the Supreme Court has really decided that when it comes to the length of prison terms, it's not going to police that at all as a matter of constitutional law. So 3 strikes cases in which the third strike was stealing a piece of pizza or some golf clubs, or I think there was golf clubs, videos, and a slice of pizza. The Supreme Court said it's up to the states. But here's why I think this is different potentially. One thing is that we have now changed our understanding of the centrality of the right to vote to citizenship and personhood from what it was in 1789. As in 1789, we were disenfranchising the vast bulk of Americans. So it would be really hard to say that disenfranchising people who've been convicted of a crime was even really a serious punishment. I mean, in a country where the vast majority of people couldn't vote, it's not problematic. Today, people convicted of a crime, and incidentally, American citizens who move to a place like Puerto Rico or Guam are the only Americans who are denied the right to vote in federal elections, who are citizens over the age of 21. They're the only ones who are just disqualified. So it's very different. The second thing, I think, is that the huge number of people who are disenfranchised for periods of time that last much longer than any period of punishment, of other punishment, is huge. So we have, as Myrna's maps showed us, we have a lot of people who've never been sent to prison at all who are denied the right to vote for good long periods of time, and that's problematic. And the third thing is, I think that we can argue that, in addition to the huge disproportionality and the lack of any functional purpose for this, this is different in kind. So it should be viewed, and it should be analyzed the way the death penalty gets analyzed, not the way prison terms get analyzed. And then if you start doing the counting, the political successes here have the same effect as political successes have had with regard to things like the execution of people with mental disabilities and the like, which is, if most of the states are allowing people who have finished their sentences, however we want to define that, to vote, then it starts to look much more like cruel and unusual punishment in the states that continue to do this, particularly because they often continue to do this for people who've moved into the state from a state where they would have been permitted to vote with exactly the same conviction. So it starts to also then look as if it's a restriction on the right to move. Because if you lose your right to vote by moving across state lines, that becomes problematic as well. And so I think by thinking outside of our traditional 14th Amendment fundamental rights or suspect classification way of trying to attack offender disenfranchisement, we may actually get some new tools. So that's kind of how I try to do the Eighth Amendment piece. Yeah.
But for the Eighth Amendment to apply, though, it would have to count as punishment.
Yes, and so the first part of the article that I wrote, which is called Convictions and Doubts, tries to establish that the only explanation for felon disenfranchisement now is punishment. And it's not regulatory anymore, because it can't be described as regulating the ability to run your elections efficiently or the like. It's punishment, and it really can only be justified now as retributive punishment. Because at the time the Supreme Court decided the original cases that treated voting disenfranchisement as non-punitive, part of the reason they were able to treat it as non-punitive is they didn't think it was a right in the first place. They thought it was simply a privilege, right? This takes us back a little bit to Jay's point earlier. And if it was just a privilege, regulating privileges is not viewed as punishment standing alone. But once you treat this as a fundamental right, normally, presumptively a fundamental right, taking it away from you is punishment. And here, actually, the text of 14.2 helps us, because it uses the word, doesn't it use the word punishment?
Or other crime.
Yeah, yeah. Right? So the Constitution itself recognizes that when you take the right to vote away from somebody who would otherwise have it, you're punishing them. So I think it's really hard to say that this is regulatory. So even though the collateral consequences point won't get you very far, because you're allowed to have all sorts of collateral consequences, many of those collateral consequences are justified precisely as additional punishment that has either deterrent or incapacitative effects. Yeah.
So we all know that felon disenfranchisement has a racially disparate impact. You referred to that a number of times. Myrna made the point that in trying to build political support for ending felon disenfranchisement, it is not helpful in many contexts to play the race card. And its litigation strategies haven't been very successful in general. And it doesn't seem likely that in 14th or even 15th Amendment litigation, just focusing on racially disparate impacts is likely to be a winner. The 8th Amendment, in this context, the court long ago said you have to show direct individual racial discriminatory intent in order to show that the death penalty is unconstitutional. It's not enough just to show general racially discriminatory.
No, that would be a 14th Amendment challenge to the death penalty. The 8th Amendment, you just have to show that it's cruel and unusual.
Fair enough.
But you don't have to show any disparate impact.
Right, but the point that's correct. But the point I want to get at is it doesn't seem either in law or in politics that we have a viable strategy for directly addressing the racially disparate impact that we all know is there. And that's a rather gloomy conclusion, so I'd like to hear why it's wrong.
So I think, here's the thing. In a moment in politics where people don't care about racial discrimination generally, racial discrimination against people who are convicted of crimes is going to be even lower on the totem pole, right? So right now, when you have a president in office and a party that is not particularly interested in eliminating racial discrimination, you're not going to succeed in politics in front of people who are in favor of racial discrimination, which I think the president at best is indifferent to racial discrimination, and at worst wants to whip it up, racial animus up as part of his strategy. Yeah, you can't be particularly optimistic that then. But the question of how long that moment lasts and whether you're ready when that moment shifts, and whether you can use things like the 8th Amendment, which treats it, I think, Myrna alluded to this, but I think it's actually something that a lot of people are looking at now, is not ceding the religious conservative view to the other side on this, which is the view that people have paid their debt to society, that none among us is not a sinner, that people can be redeemed. All of those are ways to begin to say, isn't this a terribly cruel thing? And if the discussion of race then shifts, either in politics or in the courts, somewhat towards your position, you say, and it's especially cruel because it has these discriminatory consequences as well. And it denies an entire community the ability to participate fully. And it has these intergenerational effects, right? So there are all of these arguments that allow you to start laying the groundwork. So if the politics changes, you're in a position to move forward on a series of fronts. But the question is, in the meantime, are there arguments that can appeal to people who wouldn't normally be on your side on these things? And I think, in a state like Florida, where the Republicans are really Republican and the Democrats are really Democratic, the idea that you can get a third of the Republican voters to come out and vote in favor of re-enfranchising people suggests that this is one of those areas where you can build some common ground. And I hope if you could build common ground on this, like, isn't it terrible that they're making it so difficult for people to get re-enfranchised when they come out? You can then say, and isn't it also terrible that you have like voter ID laws that make it really hard for people to vote? And isn't it terrible that you have restricted polling hours so that working people, you know, people who are working 2 jobs so that they can tithe more to their churches, don't have time to vote as well? I mean, you know, the idea is to try and meet people where they live on these issues. But no, I'm not saying within the next year or two, somebody's going to, some the federal judiciary, or, you know, I mean, actually when I was working and doing the research for this time and looking at things like the First Step Act, the president keeps saying we need to give more people second chances. Well, you know, and that was a couple of
He was talking about himself.
yeah, because otherwise nobody in this room is going to be able to vote in a year and a half from now. Yeah.
So, you know, every once in a while, I hear of a judicial obstacle that just baffles me, not being part of the clique. So, you mentioned, and Murray mentioned, the Richardson-Ramirez precedent, and you made the statement, but didn't elaborate on why it is such a powerful sort of precedent that may be obstructing the sort of legal path. But it's, you know, having read Jack's piece on this, and I'm perplexed. Explain to me why this is such a powerful precedent. I mean, why isn't it just seen as a misinterpretation of what the historical intent was, or at any rate, problematic given the general gist of what the 14th Amendment is about? Because if we really believe that these racial consequences are part of the story that's not getting discussed, or can't be approached, it seems to me this precedent problem is a major problem. So could you elaborate a little bit more on why the court thinks it's so compelling, and why they don't see the discrepancy with the overall sense of what the 14th Amendment is supposed to do?
So I think maybe there are 3 reasons that I would give for this. One is that the most obvious problem with this on racial grounds, the court thinks it's solved in Hunter against Underwood, right? So Richardson against Ramirez says, well, we're not going to use strict scrutiny, fundamental rights strict scrutiny, to look at restrictions on people's vote that are tied to conviction for crime, because we see this affirmative warrant in the 2nd section of the 14th Amendment. Now, I think Jack has shown they've gotten that wrong. And you could imagine a court, if everything had happened 5 or 6 years earlier, you could have imagined the court changing their view on this, because I'll just give you an example that's almost exactly coterminous in time, which is the Supreme Court in 1960 in Monroe against Pape held that you couldn't use Section 1983 of the Civil Rights Act of 1871 to sue cities for constitutional violations. 12 years later, and they rested that on their claims about what the legislative history of the Act said in 1871 and a couple of passages from the Act. In 1976, the court went back and overturned that in Monroe, in Monell against New York City Department of Social Services. We've come back and we've reread the legislative history, and we're convinced that while Congress didn't mean to allow for respondeat superior, they did mean that if a city's own policies violate the Constitution, you can sue them for damages. So if we had had a different court a couple of years later, they might have been influenced by stuff that says the 15th Amendment essentially overrides all this and says we have this fundamental commitment to equal racial access to the ballot. So that's one way. The second timing piece, and these are all connected with timing, is the second piece was the Hunter against Underwood piece, which is the Supreme Court held in Hunter against Underwood in 1985. If you can really show that this particular felon disenfranchisement regime is purposefully racially discriminatory, we'll strike it down. And Justice Rehnquist, who wrote the opinion in Richardson against Ramirez saying this is all fine, wrote for a unanimous court in Hunter. So it's like this. It's like the Chief Justice in Shelby County saying, "We've solved the problem." You know, we don't have the old battle days are gone. And if you can show us it's still the battle days, you win. The problem is they have this really, and Jessie got a little bit this in her talk. They've got this really weird way of thinking about, does discriminatory purpose carry over, or does it just get washed away? So that whole doctrinal area, which is not just about this, causes problems. big change is the growing recognition of the racial characteristics of the criminal justice system postdates Richardson against Ramirez. The incarceration rates for blacks and whites in this country in 1972 were not grotesquely different in the way they've become grotesquely different because of the combination of the war on drugs and the increased length of sentences, right? So we're in a different world than they were in then, but we've got a different court, and part of that difference in the court is something I alluded to in the opening remarks that I made, which is that crime rates started to go up, and people started to become more and more concerned about crime over just the period when you might otherwise have been attacking the Supreme Court's rationale in Richardson against Ramirez. So there was less and less, we became a much more punitive society than we had been. So I think it's almost like an accident of history in some weird ways. That is, if we had the war in court, but we had the huge overcriminalization that we have, they would have struck all this stuff down.
So does path,
But the reason we didn't have the war in court is because
so is 2 and 3 of your explanations, are they the potential path to maybe overturning this?
yeah, I mean, I think that's part of the path to the political overturning. And one of the things is, as the political overturning, if the political overturning continues in the way it's been going, 15 years from now, the Supreme Court will be a different court on these issues, and they will look at these issues differently, right? I mean, in the same way, I mean, think about, this just popped into my head, so it may be totally wrong, but think about the move from Bowers against Hardwick to Obergefell, which is at the time of Bowers against Hardwick, a lot of states still made gay sex a crime. They look back and they say, well, in 1868, this is what it was like. What changed in that period of time was not that the Supreme Court became more liberal from 1986 generally to 2015. It didn't. It became more conservative on almost every issue. On this issue, it became more liberal. Why? Because society changed. And as society changes, the justices' feelings about society change, and they start to infuse into the more open textured pieces of the Constitution the world in which they live. So, if the current view, which is our prison system doesn't work, we're over-criminalizing, it has a terrible racial impact, if all of those things continue to be major things in people's thinking, then eventually, I mean, this is like that old joke about that couple that goes in to get a divorce and they're like in their 80s and their lawyer says, you've been married for 60 years, why now? And they say, well, we've been waiting for the children to die. And it's a little bit like, you have to wait for this generation of judges to pass off. But after they pass off, a new generation of judges may, who have been steeped in the issues we've been talking about here, may have a very different view on whether this is appropriate punishment at all, how much the racial issue should count, and how much the fundamentality of the right to vote should count. Because I think, even though historically a lot of what explains why we have the laws we have is racism and racial animosity, even if that didn't exist, we should have exactly the same views on whether to disenfranchise people. I don't actually, I would not be happy if every state in the country except for what's the state that's more white than Maine and Vermont? There's one that's ahead of them. I think it might be I don't know. Does anybody know what the state is?
I think we're tied with Montana, basically. Maine, Vermont, and Montana, I think, are basically.
Yeah, so if every state but Montana got rid of this, I mean, you'd still have the question about Native Americans in Montana. But let's assume that Rhode Island, there's gotta be some state that's like super duper white and doesn't have any minority groups and all. You gonna tell us, Peppa?
I was guessing North Dakota, but.
Vermont's 96, Maine's 95, and New Hampshire.
Okay, New Hampshire, right? So let's say every state in the country but New Hampshire allowed everybody to vote regardless of convictions. I'd still be upset a little bit at New Hampshire, right? And I wouldn't be upset at them because, it's ever been racially correlated there.
Well, we're going to reconvene at 1:15, but please join me in thanking Professor Karlan.